I feel like I was exposed to that company during one of your earlier events.
Hmm.
A gentleman, maybe. Do you have some, Joe, maybe?
Joe.
Okay. Yeah. All right.
Oh, cool. We should go ahead and get started.
Okay.
And just knowing that someone might wander in.
So I'm just going to remain seated. I mean, we're an intimate group here. We can just talk it out. And I'm going to go through the slides, but y'all freely interrupt, ask questions. I'm here to help y'all with your questions, not necessarily go through all the content that is on the slides or I have in my brain. I can talk for hours. So we'll just start out mainly what I want to get across today. So how do I work this? How do I go next?
Oh, just
gotcha.
the arrow, yeah.
Very simple. So this is something I got up from the Startup Commons. This kind of goes into protecting your rights. They have a little license link right here, and they say you're free to use this in whatever manner you want, so long as you give us credit. So there's your credit, Startup Commons. But this is kind of an idea of what a lot of startups go through. Depending on where your company's at. There's different parts of the life cycle you'll be going through, and those different parts of the life cycle each have different legal needs. And so at the beginning, the key is to not necessarily have a big legal spend at the beginning to address all these, but the more you know at the beginning, the more you can avoid problems down the road. So there's nothing really to take away specifically from this chart. I just wanted to give you the idea that, it's an evolving process. Your needs evolve as you grow, your business and your legal needs. So starting from the beginning, there's some pretty basic questions you need to ask, like, have you formed your entity? It sounds like most people here have. The question is, what should you form and why should you form it? Forest Firm, for example, is a professional limited liability company. We're not an Inc. We're also a B Corp, which means we have a bottom line where we're giving back to our employees, the environment, and the community. Then, what state should you be incorporated in? It's usually where your principal place of business is. Some folks decide to incorporate in Delaware because they're looking to take on investments, and that's attractive to investors. Come on in. No worries at all.
That's okay.
Another consideration at the beginning of your company are your founder's documents. You primarily want to address the 3Ds, what's going to happen down the road if there's a death, a divorce, or a disability. That's the reason you have agreements between each other, because when things are going well is when you want to solve the problems for when things are going poorly. So it's better to address those at the beginning rather than be reactive. You want to be proactive in that sense. Initial contracts, as soon as you start bringing in revenue, there's usually contracts involved, whether it be with your clients, with your vendors, or with subcontractors that are helping you provide your goods and services. So in all those initial contracts, there's going to be rights and responsibilities you're taking on, and there's going to be ownership issues with possibly the content you're creating or the content you're being exposed to. And then lastly, and not necessarily.
Sure thing. About the initial contract, that's been one of the challenges for a lot of the folks as they're getting started. They don't know when to do that. I guess they stumble into it when finally somebody said, we want to work with you or whatever. A lot of times the companies not defined enough.
Right.
So the challenge is how do we put that so that it's not, it's going to cover what we're doing, even though things can change. And a lot of times it's just an informal deal, and then later on they have to come back and do this.
Right.
Do you feel like a lot of folks are ready to do that?
So as your risk adverse attorney, I say, yes, let's paper it all up right at the beginning. But as your more risk tolerant entrepreneur, you're like, well, I don't have the resources necessary to spend on all these legal fees or all this time, maybe necessarily at the beginning. Let me get some revenue first and I'll fix it later on. And you need to find a healthy balance and figure out what's right for your business. Sometimes there's a solution where you have a trusted partner, where you have a trusted client, where you're like, hey, let's do a handshake deal. Let's see if we can work this out. I'm going to give you some discounted services. You're going to provide me some insight as to what legal issues we're going to run into and what I might want to put into a contract. And maybe you and I can hash out a contract and get that signed between ourselves, and we'll formalize it down the road.
And I think that's the important thing that I've run into is that awareness of what to be asking. So you look at yourself grow, but the actual definition of the business is still a little bit fluid at that point, and what exactly we're going to provide and how, so contracts feel binding at that point.
Right.
But that awareness is
I
what
think-
I try to build in with these folks, that what to ask for, what not to ask for.
And hopefully there's an attorney or a mentor or some C-level person in another company you can reach out to and say, hey, and that's what I'm getting down here at the vendors and other resources. Like, identify people you can work with. You're in the Collider. There's a lot of people here that have been through the same situation. Ask them what pitfalls you may be running into. Ask an attorney like Sonia or I, hey, can I take 15 minutes of your time? Can you mind having coffee, or et cetera, and let's try to, identify what needs to be addressed and when it may be appropriate.
Again, at this formation stage, it's the intimidation of, it's too early to talk to a lawyer. I think
Never too early.
Right, and that's what we're trying to do. It's like, we're talking to them, they're not money necessarily billing you, sending big bills to you for a conversation, for a question.
Right.
We're trying to build relationships as well. So
Good attorneys should be doing that. Yes. Yeah, absolutely. So I think that's very critical, though, is just identifying peers that can help you out and you can talk these things out with. That's invaluable. Somebody you can always reach out to, because you need to know what you don't know.
I'm sorry that I was late and maybe not the appropriate time to ask the question, but in relation to that, I definitely have contracts with people. I'm unsure. There's some people that I definitely have an agreement with, and it's written in an email or even handwritten something just to say that we did this, this is happening. I know that's probably not legally binding, and I need to get more settled, but like doing contracts is very time consuming.
Mm-hmm. Something is always better than nothing. So the more you can put down, the better. The more meeting of the minds you can have, the better. So, if it ever made it to a court situation, or you're ended up in mediation or arbitration or some way where y'all are having to settle this down, you want to be able to point to, here's what we agreed to, whether it be like, look, we exchanged these text messages and these emails, and we both kind of, this is looking at the totality of everything, this is what we agreed at. That's one way of doing it. It just becomes a much more fuzzy way of doing math. When you have a written contract, it's a lot easier to point and say, here are our rights and responsibilities. Even when you do paper it up with a contract, though, sometimes you can end up in a situation where there's going to be unclear areas. So more is always better.
I'm just
Right.
like have all these relationships at this point and starting to be, I'm the one who's like initiated a lot of it, and they're doing it.
And it's never too late to go back and try to formalize a relationship that has been pretty ad hoc up to this point. So, if you're moving down this pathway and you're starting to, get a little nervous about where the liabilities and the risk are, then it may be a good idea to hit pause, because it does put a pause in your business, but it may end up saving you money instead of costing you money.
Can I add something else?
Sure.
So obviously it's helpful if any issues arise later on, but also having a contract or written terms is helpful for maintaining a relationship, because then you don't have to have all these issues come up that you guys are resolving as the process goes on. Then you can say, look, we're clear, this is what we agreed to, and I think that helps maintain a good relationship moving forward, because you don't have to renegotiate everything when something comes up.
Yeah, that goes back to preparing for the 3 Ds. If you do it when everybody's happy and on the same page, it's a lot easier than when people are upset with each other and there's an adverse or conflicting situation. You can just point to the piece of paper instead of having to argue with each other. So now I'm going to get into a little bit of protecting your assets and your competitive advantage. One way to do that is through trademarks. There's all different kinds of trademarks. There's your logos like the Android or the M for McDonald's, the golden arches. Your slogans, I'm loving it. Even your product shapes can be trademarked, and this kind of gets into trade dress, which I'll touch on in a second. But the shape of the Coke bottle, if you put a different label on that, it could still be infringing on Coke's products. There's also, you can even get trademarks for smells like Play-Doh, or sounds like the da-na-na, da-na-na from ESPN, and various other things. So, I mean, people have gotten really creative. Even pink insulation now for Pink Panther can be trademarked. You don't always need to register your brand to have the protections you need to move your business forward. I think the first step in putting your brand and your tagline out there is clearing it to make sure somebody else doesn't have rights. So you've got this great name, you're going to buy a website, you're going to form your LLC. Maybe whether you do it on the internet through the US Trademark Database and just some Google searches, or through an attorney, you can run a clearance search and see who else has rights out there. And the question they're going to ask is it confusingly similar? So your company is VistaNet, but if somebody had a pre-existing company called WistaNet, it may be considered confusingly similar. But then the question comes, are y'all selling the same products and services? Well, maybe they were doing window cleaning services. So you're all good because you're doing voice over internet services. But if they were doing, say, I don't know, online sales, there may be a conflict.
So case in point, there's another company with my name in California.
Mm-hmm.
They came after me. We do sell do the same things, similar things.
So you would have superior rights in your geographic region, and that's where these common law rights come in. Nice segue. So
Okay.
first use, you have superior rights in your particular geographic region. Now that gets a little fuzzy with the internet, where are you offering services? Well, everywhere. But then the question is, how strong of a contact? Are you actually directing advertising budget to California? Do you have a large client base there? Did you at the time that they started using their name? And so there's a lot of questions that come into play there. Since you have overlapping goods and services, then geographic scope appears to be different, then you could possibly file for a trademark registration, at which point you would box them into their current geographic region, assuming they didn't oppose the registration of your trademark. So you would then have, when you register a trademark, your rights then expand everywhere where no one else already has superior rights.
Okay. So like I'm primarily East Coast now, but we're moving and going out past Tennessee and beyond towards the Midwest. So.
I think exploring whether or not you could get a trademark registration, knowing that there's a risk of them opposing it if they find out about it, would be something you should consider, because as you expand and as they expand, there's eventually going to be a meeting, and you can kind of preempt that conflict and have an upper hand if you have a registered trademark and they don't, particularly since you have first use rights. Now, this is all dependent on a lot of facts and situations that I'm not aware of, so there may be other issues that we need to consider before moving forward with that. But that's a possible scenario.
You said that trademarks just means slogans. Like in our case, we have our tool is trademarked called Geo Accounting,
Mm-hmm.
and the competitor that's now turned up uses every other slogan and description of the service that we do, but they just don't use that word.
So that's something that could either be a trademark infringement because you did have those slogans first, you're possibly using them in the same trade channels.
Mm-hmm.
So it could be considered trademark infringement because you do have common law rights, even though they're not registered. There could also be a trade dress issue. So trade dress is look at the totality of your marketing and your PR. And if somebody is copying your the way you package and market your products as a holistic, in a holistic sense, then they're copying your trade dress, which is the way you're dressing up your product as
Yeah.
opposed to the single mark itself.
Yeah.
So if you're looking at McDonald's, you know, you walk in every McDonald's, they have a particular layout to their store. They'll have different color schemes on the windows and on the counters, and the booths are shaped similarly. If somebody were to open up a very similar configuration in their store, but call it, I'm terribly uncreative, call it something else that had nothing to do with McDonald's, they could still be accused of trade dress infringement because they were copying the layout and essentially trying to build off the goodwill of another company. So that's another element in both trade mark infringement and trade dress infringement, is the fact that they're trying to profit off the goodwill another company has already developed.
That's exactly like.
Yeah. So with each of these are pretty fact-intensive investigations. So you need to do a deeper dive into who was using first, when were they using it, exactly what's being copied and how they're doing it. You know, if they have IP counsel, they may be doing their best to skirt the line without hopping over it. So it just really depends.
This might be addressed later, but what about the use of your name and your body?
So it's hard to trademark, hard to get credit for trademarking your own name. You know, Beyonce and Jay-Z and several other celebrities have tried to do that as well and run into problems. I think as soon as Beyonce and Jay-Z's children were born, they tried to trademark their names. They weren't successful doing that. What you can do is prevent others from using your likeness without your permission. That's a potential avenue to deter people from using that. It's hard to get strong protections, for example, on a last name, unless it's extremely unique.
So I actually chose a brand new name when I got married.
Mm-hmm.
My ex-husband and I pretty much wanted to have names. And a former employer of mine has continued to imply that I still work there and run the same industry. And now they're using a photo of me to promote product in their store. And so I'm like, I don't know what to do about it. I've already sent like cease and desist stuff, and so I don't know if it's crazy that even if you can even do it.
Right. I mean, that's a bit of a different animal. So that involves a lot of employment issues that I'm not well versed in. There's some issues on like who took the photograph and who owns the rights to the photograph. If you have an employment contract with them that allowed for photograph to be taken at the workplace or at work events, there's a lot of situations that could be involved around that photograph as to whether or not you should still be listed on the website. There could be some deceptive trade practice acts work issues happening there where it could be possible that they're not being above board with how they're advertising and promoting their business. I don't know though. I mean, there's a lot that I don't know about that situation that I would need to know about to speak on accurately.
I'm like, yay, I just trademarked my name.
Now, so a trademark can only be obtained when you're using it in association with the commercial sale of goods and services. So if you had a company or a brand that you were promoting with your name and associate with particular goods and services, you could prevent others from using confusingly similar names if they were selling the same goods and services. But without having any of that activity, there's really no trademark rights that just exist because of your name.
Is it possible to trademark an approach? Like if I had a certain approach that had specific training components, skill sets that I felt needed to be mastered in order to achieve a certain end, can I trademark that whole like package and that concept?
We're stretching more into copyrights and patents and trade secrets at that point. With trademarks, you're looking at literally a stamped brand, a small phrase. Once you get beyond a sentence, you're typically looking at a copyright. So in the coaching scenarios, I have a lot of clients that are coaching. They'll have a brand for their coaching company, and they'll have a slogan maybe, or they'll have a particular service or product, the such and such method, or the way of doing such and such, that they can trademark as a slogan. But the worksheets and the materials you're creating are copyrightable. Or if they're not publicly available, then maybe you can protect them as a trade secret, which we'll get into in a second. Then there's possible patent protections as well if it's such a unique method that it can be considered non-obvious and unique. That's possible as well. Should I move on to the next one? Do we have any more questions about trademarks? So, copyrights and patents. So, copyrights essentially are any creative expression that is captured in a fixed medium. So, a paper that you write, a picture that you take, something that you sculpted, a video of a dance routine or a blog, anything that is a creative expression that can be captured in a fixed medium can be copyrighted. And the copyright exists at the moment that you create it. So once you've created it, you automatically have certain copyrights. The reason you register those copyrights is so you can enforce your rights. So if you're a prolific expresser, you may not want to go copywriting everything you're creating because that does cost money and it takes time, whether you're doing it yourself or through the use of an attorney. But for certain copyrights, like a certain photo that you have that you see becoming viral, or you see imitators possibly trying to create it or use it for their own commercial gain, then you may want to register your rights so that you can go out and enforce your rights against others, because you can't enforce your copyrights unless it's been registered with the U.S. Copyright Office.
So question, so specifically, I take a picture and I post it on my website or something like that. I don't put a CD or write copyright or anything like that. That's kind of one stage.
Mm-hmm.
And certain rights there.
Right.
Is there an in-between stage of putting the C on there, the copyright notice without the registration?
Well, so you're putting the public on notice, and should there ever be a situation in the future where you needed to assert your rights, one thing the court's going to ask is, well, was the other person, did they know that this was yours? Or did they assume it was freely available for anybody to use? When you're putting that copyright symbol on there, or where you're putting that full copyright notice, which I didn't do on this presentation, shame on me, on the bottom, it would say circle R, all copyrights reserved, name of company, or name of copyright owner, and or all rights reserved. That puts the public on notice that you have certain rights and you intend on enforcing them. They would not be able to argue in court, well, I didn't know about this until they filed the lawsuit, until they sent me the first demand letter, whatever it may be.
But that's not, there's still another step to officially register.
That's correct.
Okay.
You have to submit a copy of it and some bibliographic information and some other information to the Copyright Office.
So is,
And that costs money.
That costs money. It's not substantial like a patent. It's $300 or less. It changes quite frequently, and it's a little dependent on what you're submitting. And it can take time too, up to 9 months.
So for copywriting, is it the C in the circle or the R in the circle? Or doesn't it matter?
It's a C in the circle for copyrights, it's R in the circle for registered trademarks.
Okay,
Yeah.
thank you.
So patents is a bit of a different animal, and I'll just kind of run through this quickly unless y'all want to go down this rabbit hole because it can get quite complicated. But patents are for covering non-public and non-obvious matters. So information like a particular method of creating something or a particular method for performing a analytic or a new product or even a new style can be patented. Non-obvious means looking at everything that has existed in the public before the day in which you apply for your patent, you submit your patent application. Is what you've created considered a non-obvious leap from what was already out there? So if the table's already out there and all you do is take a rounded corner and make it a square corner, that might not be considered non-obvious. I mean, squaring corners is pretty out there. But possibly cutting a center out of the middle and putting a metal inset in there so that you can run cables and electricity through, that might be an obvious variation on the old table, and you might be able to get a patent on that. So there's a lot of analysis can go into what's considered non-obvious. Non-public means you haven't already put it out there in the public or started using it commercially. In the US, you get 1 year grace period. In Europe and other countries, no grace period at all. And then there's some that stretch in between there. So you want to consider before you even make an invention part of the public knowledge, whether you should file for a patent application. Trade secrets. Okay, this is one of the most overlooked intellectual property assets, and it's often the most critical to your business because your business thrives on stuff like customer lists, how you perform the functions you perform for clients, how you take their request and turn it into work product they're going to pay for. And a lot of that is done in private behind closed doors, and you really don't want your competition being exposed to those valuable assets. So no registration is required. In fact, you do not want to put this on a public registrar. What you want to do is take reasonable confidential measures to ensure that it's being kept private. So backing up a little bit to the economic value, one aspect that, of a trade secret is that it's actually providing a commercial value to your business. That's usually fairly easy to prove. There's rarely something that's going on in your business that you want to protect that isn't valuable in some way to your business. So providing economic value is a pretty broad term. The hard part is showing that you provided reasonable confidential measures. In other words, what did you do to ensure that this trade secret was kept a secret? You know, if you're posting on Facebook about how you did X, Y, and Z, then it's not considered a trade secret anymore. It's now part of a public, public data. So it says consider cybersecurity and employee policies. You know, what are your employees doing and what are they posting about? Cybersecurity is not all viruses and bugs and planning ransomware and bitcoins. It can also just be, are you letting pieces of paper leave the office that shouldn't be? Are you leaving phones, out and about and losing hardware with information on it? And so when it comes to trade secrets, this is not like a trademark, copyright, patent. This is not a one size fits all kind of a solution. What you need to do is consider a lot of things. At the beginning of your company, did the founders sign agreements that said, hey, I'm going to keep everything in confidence. Anything I create is owned by the company, not me as a founder. Your employees, as they come in and as they go, are you ensuring that they're signing agreements saying that they're going to keep everything confidential? Maybe you want to consider non-compete. Maybe you want to consider non-solicit, like they can't leave, and then solicit people, whether it be other employees or customers, of leaving and going with them. And then you want to consider what to do when they're exiting. You know, hey, did you cut off their access to the emails? Did you ask them to return any material that they may have? Did you explicitly get them to sign an agreement if they didn't have one at the beginning, saying, hey, you know, we'll pay you a severance if in exchange you'll agree to take these steps to ensure that our trade secrets are protected. Same with clients and vendors. You've got contracts with them all the time. They're going to get exposed to trade secrets. You need to make sure that they're holding all this in confidence as well, and that there may be some bidirectional concerns there. They want to expose things to you and want to ensure that you're keeping them held in confidence as well, and not exposing their trade secrets to competitors or the public.
Can you take a second and talk about your thoughts about non-disclosures?
Whenever possible, you should get someone to sign them if you're exposing them to your unique, the unique aspects of your business. Now, there's a lot of folks like investors or much larger companies that aren't going to sign non-disclosures. And at that point, which is a reasonable thing to do on their part, if you've got a Fortune 500 company and they have a lot of folks approaching them about new business ideas or new concepts, if they sign non-disclosures with all of them and say Joe and Mary both come to them with a fairly similar idea, well, one of them is going to accuse them of stealing their idea and running with it when they decide to go with one of them. So there are reasonable reasons for people not to sign non-disclosures, but whenever possible, you should try to get it signed.
I think it's interesting in that now everybody thinks that the Fortune 500 and can refuse these things. I mean, it's just like, oh, nobody signs this anymore. And these are just small investors
Yeah.
or
Yeah.
advisors and so on that like, we don't do that. We don't play that game.
And it is a line you have to tread. You know, how much are you willing to expose to somebody that's not willing to sign that? And you know, there is a point where you get in a relationship and you're trying to form a relationship or a partnership where it may extend beyond a non-disclosure agreement to a letter of intent or some other more substantive contract where you're exchanging services with each other. So, you know, if you've got to play your cards a little carefully. You know, you want to show them that you have value and that give them an opportunity to do their due diligence, but at the same time, you don't want to give away the secret sauce. So it's a bit of a hard line to straddle.
It's
Yeah.
just, and again, I get people pushing back on saying, well, we would do that, even in situations where we're at a point that that's important for that company and for the next step of that relationship. So unfortunately, that myth, I don't necessarily call it myth, but that feeling is like, oh, well, nobody does it. You can trust me. I'm not gonna.
Well, hopefully at some point there's a bargain for exchange where like they're offering you something or you're offering them something. At that point, there can be a contract involved that has a confidentiality clause in it, as opposed to them simply signing an NDA to discuss things with you further.
Yeah, I've just run into several folks who, they've developed a business plan and now they're trying to share it out there and look around and get some interested investors, and investors are saying, I won't do it, I won't do it.
It's really obvious in this town that no matter how small the investor is, they won't sign them anymore. Yeah, they just flat out refuse.
I think it's just one of those things that the word's got around saying, oh, nobody does that anymore, so now
Yeah.
everybody starts with that.
Yeah.
And very rarely is ever pushed back on because you don't want to risk that potential relationship.
And the other part of that, though, is because it's a small town, and I don't know how well you know this, but some of these investors do take the ideas and share them, and all of a sudden your idea is cropping up somewhere else before you know it. And it's, yeah,
It is a chicken and an egg problem, yeah.
yeah, and that's, yeah, it's really bad in this town, really, really bad.
It's bad everywhere.
I'm sure it is.
It really is. I mean, getting a first mover status so with a lot of these ideas, sometimes the concept itself is not protectable as your own. I mean, it's not necessarily new and novel. It's just you've identified a particular area that needs a solution, and identifying that problem is not necessarily the solution that's protectable. And so sometimes getting the first mover status is your best protection.
Well, and that confuses things too, because a lot of folks who are in that position are asking for the non-disclosure when they really don't deserve it. So it's money on both sides.
Right.
Like, what is it really about? And
Right.
of course, nobody's talking to lawyers, so it's just who's going to push harder on whether you do it general.
I'm confused. I just want to clarify what you said, that the identifying the problem is not
Is
protected,
often
but
not protectable.
The solution, the concept of the solution would be.
Can be. It could be. Right. You know, if the solution's already out there and you're packaging it for a local problem, it's possible that neither are protected. You know, opening up a restaurant that serves Ethiopian food, well, that hasn't been done here, but it's not necessarily protectable. You can tell somebody, look, you know, I see there's a lot of Ethiopians that live here. We should open up an Ethiopian restaurant. That's going to be really hard to protect. If somebody says, you're right, that's a great idea, it's an unmet need, I'm going to do that. And thank you for the idea. It's really hard to protect that unless you have a non-disclosure in place. And it's going to be hard to get people to sign a non-disclosure for a lot of the reasons that are here. So there's not a legal solution for every problem. And I think that's one of those problems that's just, you've got to just power through and figure out a way to figure out what your competitive advantage is.
Can you address what you mean by first mover status?
So the first person to jump into a new market has, you know, it's just a term that's bandied about, but first mover status is what they're granted because they now have a competitive advantage against everybody else there. They're going to have input from the first customers. They're going to have internal institutional knowledge that's going to give them an advantage over everyone else. And their brand awareness creating that market is going to be stronger than everyone else. So everyone else is coming in and playing catch up. And so the hope is, as a first mover, that you can continue to collect data and iteratively change based on that data while everybody else is coming in and trying to catch up with you.
Just list some more examples of trade secrets.
So client lists, or sometimes you have processes in-house that you encourage employees to do. Maybe you have certain step-by-step analysis you do on problems that come in from your clients. It sounds like you're in the coaching field a little bit. You know, maybe there's, when you're training your fellow coaches to go out there, processes that you use with your clients may be considered trade secrets. So you're saying, hey, here are the steps to create a valuable business. I don't know what you're coaching in, but those coaching strategies you're deploying and telling to your clients could be trade secrets. And you could have them in the consulting agreement or whatever it may be, say, hey, you agree to hold these particular strategies as a secret and in confidence, and not share them with others, because this is obviously the bread and butter of your business, and you want to be able to provide them to others at a value.
The classic example is Kentucky Fried Chicken's secret spices and Coke's formula.
Right, chemical compositions, Coke's formula, they could have been patented, but that patent would have expired 20 years after, well, I don't know what the law was in 18 whatever, but the patent would have expired, but if you hold it as a trade secret, it can last indefinitely.
And they keep the formula in the vault, and the company know it. And they can't see it.
Even, yeah, and even they have to, even if it's reverse engineered, it would be illegal to use it because they have it protected as a trade secret. I'm sure there's a technology at this point. They can figure that out. You'd be in a lot of financial trouble if you expose that.
So basically also like, what you're saying, step by step analysis, even just like a workflow that is applied to something that's not been used and utilizing a system you created for that workflow. Does that make sense? That's the same.
It could be. So, I mean, these things that you're creating, you need to consider whether or not you're even going to protect them as trade secrets or what form they're in. So if you have a structured outline or process that you're using, a workflow that you're using, and you're providing that to either people in-house or to people that you're working with, you need to let them know in some way, either through a contract or through an email or through marking the document, please keep this in confidence. This is considered a trade secret, et cetera, et cetera. There's different ways of ensuring you're taking reasonable measures to make sure it stays in-house so that it doesn't get passed around to others. So as people get exposed to it, you're taking reasonable measures to make sure that it remains yours. So I think we've touched on a little bit of this, but some other IP considerations, cybersecurity, just consider how everybody's handling the information in your company, making sure it doesn't get exposed outside of your company when on time. Okay. If you have a website, a dashboard, or an application, do you have a terms and conditions policy on your website? That's going to help define the rights and responsibilities your company has and the obligations the user has to kind of resolve conflicts before they get brought to light. And that touches also on the privacy policy. Are you collecting personally identifiable information? Are you collecting health information? If so, you need to have a privacy policy that addresses that somewhere on your website or somewhere in the provision of services you're providing your clients, because there are a lot of rules, state by state rules, European rules, and it doesn't matter that you're in North Carolina, it matters where the consumer is. So unfortunately, you could be exposed to a whole bevy of different laws and regulations depending on where your customers and clients are. Fortunately, there's some pretty uniform things you can do to be compliant with all of them. Even if you don't collect this information, sometimes it's good to just put a hyperlink on your website at the bottom and say, we do not collect this information, which stems or which deters anybody from accusing you otherwise.
So when you say collecting PII, so if you're selling something through your website and if you're collecting their payment information, you have to have a privacy policy?
I would consider putting a privacy policy on your website. Do you have to have one? No, you don't. You need to conform to certain credit card processing requirements. And I don't know these exactly, but it's something along the lines of you can't store credit card information without it being under in a locked room or in a secure database. I don't know if you know any of this. You can, however, process credit card information, but you can do it through third-party vendors that have their own databases and security measures set up. What you don't want to do is get in the habit of taking credit cards over the phone, writing it down, putting it on a piece of paper, and then saying, yeah, I can charge it next month for you too, or et cetera, et cetera. You don't want to store that unless you're conforming to whatever rules they may be. And frankly, I don't know what they are exactly.
They're long, lengthy, and involved.
They
If
are.
you don't want to get involved with it, I do. I have to do that, so
Yeah, it's usually better to use a third party.
Yeah.
Unless,
as much as we can.
Mhm. Domain ownership and management. This is a really big one that comes up down the road when a founder or an employee or an acquirer, like a founder or employee is leaving or an acquirer wants to buy the company. Usually somebody sets up the website before the company gets formed and before it ever really gets formalized. And by the time they're rocking and rolling and providing services, nobody ever thinks about this again. It's in their Yahoo account and they forget to use their Yahoo account, or that employee leaves, or the founder leaves, or something happens, and now they don't have access to their domain anymore. Or somebody gets a little upset with how they left the company and decides to shut it down and freeze them out. Like I see this happen a lot, and it's a really easy solution. Go and check out your domain, see where you can do a whois lookup if you want, and it'll show you what email addresses are listed under the domain. Make sure you have 2 different ones, one for an IT person, one for just a general email address for your company that you can use. So you always have access to it, no matter who's at the company. Very important.
Intellectual property patents and things like that, a lot of times happen that way too. Somebody creates a patent as an independent, then they form a company to apply it.
Right.
And never transfer it over, and then something happens to them.
Part of those founding documents need to include, hey, I'm granting ownership of X, Y, and Z to the company, as opposed to the owner. At minimum, grant a license to the company can use it, and you can't accuse them of infringing it, although a lot of times the facts will show that the company has certain rights in it, shop rights or whatever. Yeah, that happens a lot with founders. A lot of stuff, just people assume it's with the company, and then when you go back and you start doing your due diligence, you find out, okay, the owners actually own the rights to this, and it hasn't been transferred to the company. At that point,
Especially like
it can get
when they leave or you sell the company or whatever, it just gets messy.
Right.
It hasn't been transferred.
right.
Stuff.
Things change because at that point, people have changed and the situation has changed. And then contractual obligations. You're going to have a lot of contractual obligations with various clients or with subcontractors or vendors. Maybe during those contract negotiations, they said you're not allowed to pass on this contract to anybody else. You can't assign ownership of it. It's non-transferable. Maybe they say you have to keep certain information in confidence, or you have to return materials at the end of the term, et cetera, et cetera. So just always be aware of what you're signing. Try not to sign things blindly. You don't necessarily have to have a lawyer look at it all. Of course, I'd want you to, because it makes me feel more comfortable. But you should go through it with a fine-tooth comb and understanding what rights and responsibilities are on you during the contract and any that may exist after the contract is done.
In the reverse of the founder employee scenario, what, as an employee, if you do something, is all of that automatically, if it's a concept or idea or a product or whatever, and does it automatically become the employer?
So I won't bore you with the 7-factor test and all that, but the general analysis you need to do is, are you doing it as part of your job description or not? And secondly, are you doing it with company resources, on company time, or at the direction or control of the company? So I started going through some of the factors, but there's a lot of factors that can be considered. Depending on your role, it could be considered more so that a lot of what you're creating is considered the company's work product. Like if you're the chief innovation officer, well, you're going to be doing a lot of innovating for the company. If you're a subcontractor that is delivering pizzas for the company, maybe a lot of what you're doing is not going to be considered owned by the company. So it really depends on where you are, what your relationship with the company is, and then whether or not you're using their time, resources, and direction to create it. This happens a lot at universities. A professor will moonlight and figure out, do research on different topics that are kind of falling within what they do for the university. Did he do it at home in his garage? Did he do it on the university lab and use the expensive equipment? It can get muddled pretty fast, the analysis. I think we bumped right up against the time here.
Yeah, just about, maybe a few more minutes for questions. I don't know. Can you repeat what you said about the domain ownership and management to Google? Who owns, and then just like an email address?
There's, if you Google Whois lookup, you'll see a lot of resources for ways to put in your website address. You put it in there and it will spell out 4 different categories of name, contact name, owner, address, and email contact. Usually for people, all 4 of those categories are going to be the same ones, like, I forget this, registrant, owner, user, and something else. Usually they're all the same. So you want to look at that and make sure that that is in the company's name and not in individuals' names. I know, at a lot of companies I've worked at in the past, we'll say, hey, IT person set this up, and then we go and look it up, and it's IT person's name, contact, and all that, and it's not our company at all. So whenever our company has a problem, we want to fire the IT person, they're in complete control, and we're not. So that can become a problem. I always suggest having 2 people listed. That way, if one person leaves, you've always got a backup plan. And for one of the backups, you can always just create your own email address, it@companyname.com, and give a couple people in the company access to that. They don't have to have access to the domain, those passwords. They can have access to that. You can keep, some separations. Got my email address. If you have any questions, happy to help you all out.
Thanks so much, Lyle.
Mhm.
That's great.
You say you have more questions?
So can I make it?
We can talk a little bit after this if you like.
What are you up to the rest of the day?
I'm going over to talk to Crunchy Bananas for a little bit.
Oh, cool.
And there's a charcuterie place I want to go stop by on my way out of
What
town.
is that called?
I'll have to look it up. I don't know, but I want to buy some meat and cheese.
I've heard about a really good new
Yeah.
charcuterie place. We actually ran into someone who was hiking